counsel Elison Karuhanga, a partner at Kampala Associated Advocates, but also one of the people who have expressed interest in representing Uganda Law Society at the Judicial Service Commission. Mr. Karuhanga, welcome to Bbeg Media.
It's always a pleasure to be with you, Idris, and to be on Bbeg Media.
Mr. Karuhanga, people would want to know, who are you? Who is Elison Karuhanga? I mean, you have called yourself the counsel's lawyer, the lawyer's lawyer. Who are you?
I am the lawyer's lawyer. I am an advocate of the courts of judicature. I am a partner in Kampala Associated Advocates.
Yes.
I am currently a candidate for nominee of the Uganda Law Society to the Judicial Service Commission. I am a ferocious advocate for the causes and clients that we believe in. And I am ultimately, and I have been for a long time, an advocate. I started my career working in DFCU Bank. I progressed to work in the Attorney General's office in the Ministry of Justice and Constitutional Affairs as a state attorney. I also run a small law firm called Karuhanga and Company Advocates, and now I'm a partner in Kampala Associated Advocates. My career trajectory has taken me through the corporate bar, the state bar, a small firm, and a large corporate firm. I have a broad spectrum of understanding of legal practice in Uganda. I have appeared before literally every court in this land. I have multiple instances appeared in the Supreme Court of Uganda. Even last year alone, I made about 2 or 3 precedents coming out of the Supreme Court and the Court of Appeal. I have appeared in the East African Court of Justice. I have appeared before every judge of the High Court. I have appeared before countless magistrates' courts. So I am a lawyer's lawyer. A lawyer's lawyer is what I consider myself.
Then what do you say to some of your critics who claim that you're not, to use this term, you're not a foot lawyer? From your resume, it appears like you have a comprehensive experience in the practice, but there are some critics who say you're not a foot lawyer, a foot soldier lawyer. That in some of these battles of the legal fraternity has had, you haven't been present.
I am not just a foot lawyer or a foot soldier. I'm even a general in terms of legal battles. I think I have fought a number of legal battles in this country and before a number of courts. I think the idea is that if you think about what we are running for, the Judicial Service Commission, the Constitution says that you should have 15 years practice and be a member of the Law Society. So what was in the mind of the person who wrote the Constitution? What kind of lawyer was he thinking of? He was thinking of a lawyer who is a member of the Law Society, who has been active in its affairs, who has a good amount of experience. But I can also imagine that in the mind of the frame of the Constitution, we are thinking of someone who can voice the concerns of lawyers because he knows those concerns, because he lives those concerns, because he has argued cases, because he knows what happens in the courts. In fact, I want to suggest that when the framers were sitting down to write the Constitution, the advocate they had in mind was me.
Earlier this year, beginning this year, you went around the country meeting various lawyers in different parts of the country. What kind of impression did you get from these lawyers, especially about your representation on the Judicial Service Commission? Did many of them welcome your programs? Did they express support for you? Did they have reservations about certain things within the legal fraternity that they think need to be ironed out? So what was the general picture?
I have met a number of colleagues in Kampala and in the wider country. I had a fascinating opportunity to tour 25 districts in 23 districts in about 5 days, in 7 days, and it was a fascinating opportunity. But I've also had a fascinating opportunity to speak to colleagues within the city. The concerns of lawyers are important. I think we've had very positive feedback towards our candidature. That's your question. But also we've had deep discussions with lawyers about the sort of judicial system they want to see and about the type of judicial system that we're having right now. In many parts of this country, there are judges holding dockets of 1,000 cases. The Court of Appeal right now is sitting on a backlog of 12,000 cases. The Court of Appeal, out of 35 judges, has only 13. Right now, there are 7 offices in the Court of Appeal, fully furnished, ready for judges, but there are no judges there. You are finding across the country challenges to do with backlog, massive backlogs. People waiting 10 years, 15 years to get judgments at first instance. People waiting months on end. Civil sessions, even as we speak right now, civil sessions being cancelled in our courts in response so that they can have criminal sessions, because there are many people whose average time on remand in this country is 5 to 7 years. In many instances, longer than the sentences themselves. And what I've seen from colleagues, if you bear with me, what I've seen from colleagues is that there's a strong desire in the practice for a better practice. Lawyers are not just businesses. Lawyers are a service, an essential service that delivers justice. So what we have seen in all of this is this. Lawyers need solutions. The current system, as it stands right now, cannot cope, and it needs serious reform.
You have enumerated some of the challenges that the judiciary faces, the backlog, the fact that we need more judges, say, at the Court of Appeal. As one of the representatives, as one of the people who hopes to be a representative of the Uganda Law Society at Judicial Service Commission, what specifically do you intend to do to alleviate some of those problems?
Some of the things which we are proposing. Right now, we have a serious shortage of judicial officers. Article 142, Clause 12 of the Constitution empowers the President, on the advice of the Judicial Service Commission, to appoint lawyers in acting capacities as judges. We need to take this concept and apply it more creatively in a way that handles the problem while understanding the resource envelope limits. Lawyers need to be the reserve of the judiciary. Lawyers need to be the clearing and forwarding agents of justice. And how is this done? If lawyers, we need right now about 100 judges, 150 judges. We have 250 magisterial areas, but we don't even have half the number of magistrates. The judiciary has done a great job so far building courts and trying to make them accessible. But one of the things we need to do very quickly is to make sure that instead of appointing someone as a judge for 2 years on an acting basis and then confirming that person as a judge thereafter, if we can appoint lawyers on a temporary basis for mission-based work, if you say there is backlog here, we appoint 10 or 50. If we need 100 judges, we appoint 100 lawyers for a very specific period to clear the backlog, 60 days, 80 days, 100 days, for criminal sessions. They finish this work and they go back into their chambers. The judiciary needs a reserve. The judiciary needs reinforcement. The judiciary needs the lawyers to be the reinforcement. In taxation, you know, the URA doesn't just do all your tax work now. They have clearing agents. The judiciary needs clearing agents. The judiciary needs that reserve. And the lawyers have the necessary skill and qualification. For me, that's one quick thing. There are many others. The use of technology. You know, court must not just be a building. Court must be a service. We must be able to deliver a service to the people of this country called justice. If there is no court building in a place, people need not travel. Technology can bring the courtroom right down to where people are. Some courts also need to be mobile. We need to be sitting on mobile courts where even if there is no building, but you need someone there, the courts can move around as mobile courts. The idea that we can continue to deliver 21st century justice in a 17th century way needs to end immediately. People have land disputes, family disputes, property disputes, criminal disputes, civil disputes that are crying out for a solution. Lawyers are finding it hard to offer solutions to clients in a system that is simply broken. The lawyers are working hard, the judicial officers are working hard. We have a crisis of health in the judiciary. If someone has 1,000 cases a day, how will that person deliver justice? Many of them are sitting 16-hour days, 7 days a week. Though they are not sitting in court for 7 days, they are working for 7 days. Many of them have fallen sick. We have a health crisis in the judiciary because of the pressures that are coming. And I think we need to relieve these pressures with creative solutions that are practical and that are rooted in the everyday reality of lawyers.
People have decried the issue of injunctions. You know, so very many people often when they go to court, of course injunctions sometimes occur due to a number of factors, either the presiding judge is sick, or maybe some documents, one is missing, certain documents of evidence. But again, they're saying that has slowed down the process of seeking justice. Many ordinary people on the street, that they go to court, you find one case is handled, one case that could be handled in 3 months, is handled, takes 3, 4, 5 years. Currently, the election of a ULS representative is also under some form of injunction. How do you think that issue needs to be? The matter of injunction, I know. As a lawyer, how do you think we can handle it better? As a country or as the judiciary, how can they handle it better? To a level where we have less injunction, where cases move smoothly.
Okay. For me, the bigger challenge is backlog. The use of injunctive relief, what lawyers call injunctive relief, what people call injunctions, can be a useful tool in the toolkit of justice. Because if someone is having their property destroyed right now, they may need justice right now and they may not be able to get a fair hearing quick enough. So we have the doctrines of injunction that is supposed to be a stopgap measure. Keep things as they are, let's hear if we can confirm. But because of the overwhelmed nature of the system, they are being easily abused. People get them in quickly and you find an injunction lasting 10, 15, 17 years, 20 years. People are still on an injunction. That needs to change because we need to make sure that what enters the court system gets out of the court system. And that it needs to do that quickly. And we need to do that practically. It must not just be rhetoric. We must have ideas. The ULS injunction, though, is different. In my view, it is unfortunate, and I've been saying this, that the court stopped a democratic process, the democratic expression of the will of the members of the Uganda Law Society. And although it was delayed, we've been saying and will continue to say that nobody can stop the reggae. People will have the choice and they will make the choice of who will lead them and who will represent them on the Judicial Service Commission. And I think it is important that these sort of decisions create unnecessary discord between the bar and the bench. In my view, with great respect, we need to have a situation where the Uganda Law Society, for the first time, is able to express itself. You know, it's important for the Uganda Law Society to express itself because we're the only people in that Judicial Service Commission who live and breathe in the courts every day. An election to the Judicial Service Commission is a livelihood election for lawyers. It's a justice election for Uganda, and it is an absolute shame that it has been delayed for as long as it has been delayed. And I'm sure that the court will be giving us reprieve sooner than later.
The new ULS president has started with a bang. Isaac Semakade has started with a bang. Some say he has brought vibrancy within the Uganda Law Society. Others say he's shaking tables with expensive drinks that maybe he needs to calibrate a little bit. What is your opinion about Isaac Semakade, and especially his efforts in trying to reform Uganda Law Society?
I think that the contribution of Isaac Semakade has been important to the Uganda Law Society. If you look at the fact that for the first time, and when we move away from all the other things, because I know there are many things people will say, but if we look at results, the mere fact that for the first time in the history of the Law Society, since 1995 at least, when the Constitution was passed, lawyers are being given a chance to decide who will represent them on the Judicial Service Commission, and that there is a fight against that democratic exercise, is for me a massive accomplishment.
Was there a point before when a ULS representative was elected before? Was there a point?
No,
before?
This is the first time, and I can tell you why.
Someone told me, I think the Remy Kasude Rain it was. Yeah, I don't know. We need to check on the Remy Kasude Rain. But if we start from the 1995 Constitution, yes,
when the Judicial Service Commission was established, the Constitution provided that the President shall appoint representatives, but 2 of them shall be nominated to him from the Uganda Law Society. So the question was always, who is the Uganda Law Society? It was a question of identity.
Yes.
The councils that we elected always sent us representatives,
Yes.
sent the 2 representatives. In 2015 or thereabout, Mr. Semakade filed a suit in the High Court of Uganda saying that the way ULS is conducting its affairs is undemocratic. And so we came together, ULS decided at that time, I think it was during the reign of Ruth Sebatindira, the Uganda Law Society decided at that time that let us resolve that issue amicably. And an injunction was sought, actually, to stop a ULS AGM, and the injunction was not granted. But the ULS on its own said, if there are questions about our processes, let us go back and we discuss them. And I remember I was very present in all those discussions. And we sat down and we made regulations in 2016. And these regulations decided in them, Regulation 13, that the Uganda Law Society shall elect representatives to statutory corporations that require ULS under the law to send a representative.
Even KCC.
Yes,
Well,
all UCC, many.
Yeah.
So we then, unfortunately, from 2016 when we made those regulations until today, we have not been able, for one reason or another, to have those elections. This is the first time. Now, a member of the ULS called Mr. Kalali, Stephen Kalali, went to the High Court to challenge why we don't have these elections. And after he won the case, the Uganda Law Society appealed. But fortunately, under this president of ULS, we are going to have this vote. It's so important for the members of the Law Society to have a debate amongst themselves about the sort of representative they want, and by extension, the type of judicial service they are receiving from the country for the judiciary. Lawyers are 5,000 only, but we represent 45 million people. The Ugandans do not have right of audience in the courts, and the many who are using their own skill to represent themselves are suffering from gross injustice. The Uganda Law Society's decision to have this election is crucial, is important, is historic, is undeniable, is reggae, and nobody can stop reggae.
What would you say about the politicization of this race? I mean, some people say it's unfortunate that some people have been labeled this, labeled as belonging to another camp, while the matter at hand is legal. What would you talk about the politicization of your race? We have seen a lot of statements made on social media platforms. You see, this one belongs, candidate A belongs to this camp, candidate B belongs to that camp. Don't you think that that in the end may drown out the real essence of why the thing is important? Does it matter anyway which political shade the person who ultimately is elected to represent ULS at the Judicial Service Commission, what political shade or platform they subscribe to? In your view, should that matter?
In my view, it shouldn't matter. But you see, you don't expect, I say this with great respect, an election brings forth many things, and including some people with lazy thinking, low energy, and even what we would call low skullduggery, just cheap politics. That should be expected. What I know that discerning members of the Law Society will look at, they will understand that this is a livelihood election. They will understand that whoever is voted is going to be there for a few years, and whilst they are there, they are going to be determining things that affect the Law Society. Are they in touch with everyday legal practice? Do they have cases pending adjournment? Do they know the pain of waking up and preparing for a case? Do they know the pain of losing when they should have won? Do they understand the pain of the Law Society? Are they thinking generally about the solutions? The debate that the election offers members, it will offer those who come with no ideas, who come with allegations, insinuations, and imaginations, who come just puppeteering and sloganeering. They'll come because they have no ideas and they have no energy. But it'll also offer other candidates who come with ideas and energy. And I want to submit to members of the Law Society that in the group that comes with ideas and energy, I am not only there, I want to submit that I am right at the front of that group. I am saying, let us change the way we do practice. Let us change the way justice is delivered. Let us have a discussion and a debate about justice about the judiciary, about the reforms that we need. And those who want to talk about political parties, there's a time this year when they shall have enough time to have that conversation. This is not an election about friends, it's not an election about parties, it's not an election about persuasion. It is a livelihood election. You can go and vote for yourself to eternal damnation, or you can go and vote for yourself to hope. You can go and vote for a friend of yours who will not say a word when the word is needed.
Bannayuganda mwenna mutegeezebwa nti akakiiko k'ebyokulonda kateekateeka okuzza obujja enkalala zaffe ez'ebyokulonda wamu n'okuwandiisa abakadde n'abo abateesobola. Enteekateeka eno egenda kubeera ku buli muluka okwetooloola eggwanga lyonna okumala ennaku 20. Okutandika ng'ennaku z'omwezi 2 omwezi guno ogwa January 2025 okutuusa ng'ennaku z'omwezi 10 omwezi gwa February 2025 buli lunaku okuva ku ssaawa 2 ez'okumakya okutuusa ku ssaawa 12 ez'akawungeezi nga kw'otadde olw'omukaaga ne Sande awamu n'ennaku enkulu zonna. Okuzza obujja enkalala kugendereddwamu okwongeramu ebikwata ku balonzi abatuukiridde ebitali mu lukalala lw'abalonzi olw'eggwanga. Ku mulundi guno bino wammanga bye bijja okuba nga bikolebwa. Okuwandiisa abalonzi abapya ate nga batuukiridde. Okukyusa ebiwandiiko ebikwata ku balonzi abandyagadde okukyusaamu ku bifo we balondera. Okutereeza ebikwata ku balonzi ebyawandiikibwa mu bukyamu.
For a voice that understands practice, you can vote for a theoretician, a dreamer, an imaginer, a pretender, or you can vote for the lawyer's lawyer. And I am convinced that when this choice is put to colleagues, they will vote for Elison Karuhanga, the lawyer's lawyer.
How confident are you about sweeping the votes? Internally, what do your numbers tell you? Of course, I know by this time you have done. Do you feel confident you carry the day? Are there some things that you think, have you encountered any challenges, by the way, in your besides the injunction, in this countrywide challenge? What are some of the challenges, either to you or to the legal profession, that you think?
Of course, we have challenges. We have judicial officers who are serving at magistrates level, so many stations. We have challenges to the profession first, of access to become a magistrate. Just how transparent is the process of appointment? And many colleagues apply and they have no idea about what happens at the end. We have challenges about the way discipline is done when complaints are made. We have challenges about access to justice. For the campaign side, how confident are we? I'm confident that as long as we continue to engage with members of the Uganda Law Society, discuss the issues of the Uganda Law Society, discuss the issues that affect judicial service and judicial practice in this country, I am confident that we shall win. Because let me tell you, this is a campaign about ideas, and the ideas we are putting forward are ideas whose time has come. That is why for me, we are running a reggae-style campaign, a campaign of energy, rhythm, enthusiasm, and hope. And we are sure nobody can stop reggae.
Elison, as we wind up, what is that one final word? What is that one message that you have for either your supporters, for lawyers within the fraternity, and for those who are wishing to see reform within the Judicial Service Commission? What is that one word you want to leave with them?
My final parting shot to colleagues would be that I understand that there's some apathy as a result of the orders stopping us from voting. I understand there's some concern among members about the future of legal practice. I understand there's concern about members about the ability of justice to be delivered. I understand all of that. My message to them, though, is we need to come together. We need to continue having the conversation. No matter how long people want us to hold, we must not hold the debates that the democratic exercise is bringing. And once we have those debates, and once we bring those debates to the core, I can assure you, members, we shall be able to overcome. We shall be able to overcome because, like I've said, it is like the drum beats of reggae. It is like music. It is about harmony. We need harmony, yes. We need rhythm, yes. We need moves, yes. We need action, yes. And once we start moving, we are unstoppable because nobody can stop reggae.
Thanks very much, Mr. Karuhanga.
Thank you so much
for sparing time for Bbeg Media.
It is my honor to be on Bbeg Media.